Today we're here to discuss the types of courts in the United States. So not only will we talk about the court system, but the different types of courts. So our goal is to explain the dual court system in America and to explain the makeup and composition and duties of the Supreme Court of the United States. So without further ado, let's start by taking a look at where we fall in the Constitution. So we know Article 1 sets up the legislative branch, Article 2 sets up the executive branch, and Article 3, of course, will set up the judicial branch of the government, which is the Supreme Court. And Article 3 sets up the branch of the government that is responsible for interpreting the laws. And we've already gone over what that means, so now let's take a look at how the Supreme Court and how the lower court systems actually function. So when we look at types of courts, there are a number of different types of courts. We have in America a dual court system. So when we look at the dual court system, it's sometimes called a dual court system because we have federal courts, or sometimes what are known as national level courts, and then we've got the 50 state courts. So if we look at our diagram of the court system, there are 91 or 94 U.S. district courts. It gets confusing. Some books say 91, some books say 94. We're not going to get into the intricacies of why, but just understand it depends on how you count the courts. Either one will be acceptable on the test. And then we've got 12 or 13 courts of appeal, or sometimes what are known as circuit courts. Same thing, there depends on what book you look at. Some say 12, some say 13. And then, of course, we've got one Supreme Court of the United States, and that makes up the national court system, or what we call the federal courts. But then each state has their own court system. So each of the 50 states has a court system, which is sometimes called the district court system at the state level. So every district, every little district within each state has their own court system. Here, if you're in Plymouth or Canton, you're in the 35th district, I believe. And then within that system, we've also got state appeals courts, and we've also got a state Supreme Court. So just like the national court has different levels, the state Supreme Courts have the state court system. So just like the national court system has different levels, the state court system has different levels as well. So let's take a look at the federal court system, the national court system. At the national court level, there are district courts. So all across the United States is broken up into different districts. If we look at the state of Michigan, it is divided up into two districts. One district makes up the entire eastern portion of the state of Michigan. That is located in Detroit. Another court makes up the entire western side of the state, plus the Upper Peninsula, and that's located in Grand Rapids. Then, if we move on from there, we move up to the Federal Appeals Court, which is divided up into different districts. This is where there are 12 or 13, depending on how you look at it. And you'll note that Michigan is in the 6th district for the federal appeals level. And that court includes Michigan, Ohio, Kentucky, and Tennessee. And that court is located in Cincinnati, Ohio. So if you're going to appeal at the federal level, you'd have to travel to Cincinnati, Ohio. Now, within each court system, we have what is known as jurisdiction. And jurisdiction is the power of a court system to hear a court, or the authority of a court system to hear a court. So whether we decide whether it's a district court case, or a state court case, or whether it's an appeals court case or a Supreme Court case, that is all determined by a number of factors, including where the case took place, what the subject matter is, and the parties involved. So based on what we're suing for, or what the crime committed was, and based on where the parties are from, we could have different jurisdiction, the right of the court to hear the case. And then there's what is known as concurrent jurisdiction. And what that means is that there is shared jurisdiction between state and federal levels. That means several different courts may have jurisdiction at the same time. And we'll get into that in a minute. So basically, whenever you start a court case, it's going to follow one of two paths. You're either going to start at the state district court level, then you can appeal to the State Court of Appeals, then you can appeal to the State Supreme Court, and finally to the U.S. Supreme Court. Or you can start at the federal level at the U.S. District Court, appeal to the U.S. Court of Appeals, and then finally to the Supreme Court. Nothing is higher than the Supreme Court. Once the Supreme Court rules, that is the end. That's why the Supreme Court is a court of final jurisdiction. When we look at the state courts, or oftentimes what are called district courts, they are there to interpret state laws. So if you break something that is only a state law and not a federal law, you would go to state court in order to hear that case. Some other examples of when you would go to a district court: if you are dealing with marriage or divorce or adoption cases, those are handled by state courts. Most civil suits, so if you are going to sue somebody for money or for reparations or damages, that would take place in a district court. Personal injuries usually fall into civil suits, and that would take place in a state court. What is known as probate, so basically if you're dealing with how do we settle a will or an estate after somebody dies, that goes to a district court. And then usually most contracts will go to a district court as well. When it comes to federal jurisdiction or the national court jurisdiction, federal courts have original jurisdiction in the following cases: anytime you commit a federal crime, anytime you have a civil suit where there is what is known as diversity of citizenship, meaning people are from two different states, and the value of the suit is over $75,000, you could sue in federal court if you wanted to. Anytime you are dealing with bankruptcy or naturalization, that is the process of becoming a citizen, that is a federal court issue. When we're talking about federal agencies, that is a federal court issue. And then anytime we're talking about admiralty or maritime law cases, so something happens at sea, that is handled by the federal courts. The Supreme Court also has original jurisdiction, but it's kind of rare for the Supreme Court to exercise this. They don't use original jurisdiction that often, maybe less than 5% of the overall cases heard by the Supreme Court. But the Supreme Court does maintain original jurisdiction in any federal case. So anytime you have broke a federal law or a federal statute as they're called, or if it's a maritime issue. If the United States government is a party, which means if they're being sued or they're doing the suing, that could start in the Supreme Court. Anytime you've got a case involving foreign countries suing the United States, that could take place in Supreme Court. If two states want to sue each other, that takes place in the Supreme Court. If there is a question about a treaty, Supreme Court. Cases affecting ambassadors and diplomats could go to the Supreme Court if they're not granted diplomatic immunity. More on that in a different unit. And then finally, the Supreme Court also has what is known as appellate jurisdiction or appeals jurisdiction, and they also have final jurisdiction. In any case, whether it's a state level or a federal level that deals with the Constitution or a violation of your constitutional rights. So we can look at this from your book. There are several different situations where we could try to figure out whether it's federal or whether it's state jurisdiction. So first, let's look at the scenario of somebody robs a bank in California. Is that state or is that federal? If you said federal, you are correct. This one gets tricky because robbing a bank is a federal law. It's a national law, so that would go to the federal court system. So, Citizen X of Michigan sues Citizen Y of Massachusetts for $80,000 in damages caused by a car accident in Michigan. What court system is that? Yes, if you said concurrent, you are correct. Because it's a citizen from Michigan suing Massachusetts, we've got diversity of citizenship, which means it could take place in the federal court, or we could go to either one of the state courts. Finally, Citizen Z of Ohio has her car repaired by AJ's, the local dealer. Her car breaks down on her way home. She sues the repair shop for breach of contract. Where would that take place? And if you said state court, of course you're correct, because everything takes place in Ohio. Why you'd want to be there in the first place, who knows? Because everything takes place in Ohio, it is purely an Ohio matter. So when we talk about a jurisdiction, it gets crazy because it's not only a matter of federal jurisdiction, national jurisdiction, versus state jurisdiction, but we also have a different level of jurisdiction, what is known as original, appellate, or final jurisdiction. So anytime we hear a case, the first time a case is heard, it is what is known as original jurisdiction. And in most cases, original jurisdiction starts in a district or a state level court. So the first time a case is heard, it is heard in a court of original jurisdiction. And the job of a case The job of the courts in a case of original jurisdiction is to decide what are known as the facts of the case. And what we mean by facts is what you typically think of when you see a court case on TV. You've got lawyers for each side, you've got a defendant, you've got a plaintiff, you've got judge, you've got evidence, you've got witnesses, and whenever we hear the testimony of the witnesses and look at the evidence, that is what is known as the facts of the case. The facts of the case only get heard in a case. The facts of the case only get heard in original jurisdiction. This is the time when we're deciding, are you guilty or not guilty? Are you responsible or not responsible? This is when we're going to call in the witnesses. If you don't like the result of that and you meet certain criteria, which we'll go over in a second, you could appeal, or you could go to the next step in the court system, and that is what is known as appellate jurisdiction. Sometimes we call this the higher court or the appeals court. And when you get to a higher court or an appeals court, you are not there to look at the facts of the case, but rather you're there to decide the application of the law. The only job of a court of original jurisdiction is to decide, was the evidence properly The only job of an appeals court is to decide, was the law properly applied. They're not there to look at new evidence. They're not there to look at the old evidence. They're just there to decide, was the law properly applied. And so in a case of appellate jurisdiction, you don't have a jury. You actually let the justices decide. There are lawyers for both sides, but there are no witnesses. Because we're not deciding the facts, we don't need witnesses. We're just looking at, was the law properly applied? Reasons why you might appeal a case, and again, you have to have grounds to appeal. You can appeal for any reason you want, but an appeal will only be granted if you meet the following conditions. If there is a question about the application of law, if there's questions about whether or not the law was properly applied, that goes to an appeals court. If there is question as to whether or not your constitutional rights were violated, that could go to an appeals court. Or if some part of the trial process was unfair, which generally means that either the law wasn't properly applied or it was unconstitutional, then you could appeal the case. You can't appeal just because, hey, I was found guilty and I think I'm innocent. You have to have a reason that dates back to the application of the law, that goes back to, was the law properly applied? So when an appeals court hears a case, they have several options. Option number one is to reject the case, and this actually happens most of the time. If the appeals court decides you don't have reason, you don't have grounds to appeal, then whatever the lower court decided, whatever the district court decided, that is the official ruling. An appeals court, of course, could decide to hear a case. This is a little bit rarer. And if they decide to hear the case, then they've got a couple options when they reach a decision. They can, number one, uphold the original case's finding. They could say, whatever the lower court found, we agree with them. They could overrule the lower court, saying that basically just the opposite. Whatever the lower court found, if you were found guilty, you're now innocent. Or they could modify the case. They could change a particular part of the lower court's case, but not the entire decision. So those are all options available in the appeals process. So again, if we want to look at our diagram, courts of original jurisdiction would then go to an appeals court, so the U.S. Court of Appeals or the State Court of Appeals, and then you could appeal to what is known as a court of final jurisdiction, and there's only one of those in the United States. That is the Supreme Court of the United States of America. And so if we look at that, the Supreme Court has the final decision. Once the Supreme Court rules, the case is over. So if we want to look at a layout of what the courts look like, you can look at this chart and you can see how the court system is laid out. If you want to see what actually happens in a court of appeals versus a normal court, which is what you're used to, let's take a look at the following video.
Appeals for the State of Arizona Division 2 is now in session.
So we've got the justices walking in, a 3-judge panel, and then we're going to see lawyers from each side make their arguments, and they're going to base their entire arguments off of the Constitution. They're not going to talk about new facts. They're not going to talk about evidence. They're only going to talk about the actual application of law.
Counsel, may we have introductions, please?
Yes, Judge Bill Reisner for the appellant.
Thank you.
Dennis McLaughlin with the City Attorney for Defendant Appellee Roger Randolph, who's present in court.
Kim DeMarchi for the intervener defendants, the campus acquisitions entities.
Counsel, thank you all. Counsel, we have read the briefs. We reviewed the entire trial court record, including the transcripts that have been filed with the court. So we are very familiar with the factual background. You may not want to spend a great deal of time with a dissertation of the facts, except, what supports your argument. But with that, I think we're ready to proceed. Mr. Redmond?
Thank you, Your Honor, and may it please the court, opposing counsel. I reserve to arguments they raised. Initially, I'd like to spend a little as you know, I think Whitman versus Moore talked about how it was a notorious fact that the Constitutional Convention, that the central issue in the selection of delegates related to these three issues, and the approval of the Constitution itself. And this morning I have the key issue, which was that in Arizona, the people didn't give the entire package of their powers or their legislative authority to the legislature. They truly reserved to themselves the powers of referendum petitions by the city clerk, complied with the state constitution, complied with Tucson City Charter, and complied with Tucson's code. What the clerk has said.
Before you leave that,
yeah.
Let's stick with the Constitution. And I think it's undisputed that the powers of initiative, referendum, and recall are critical, and it's reserved to the citizens of the state of Arizona. That's undisputed, has to be. But what does the Constitution tell us about? You referred to the powers that cities have also under the Constitution. But what does the Constitution tell us about whether the legislature or the Constitutional Convention, whether they have decided to allow the separate counties or for that matter, the municipalities to come up with their own procedures for referendum in particular?
Well, they have said that the cities and counties can come up with their own within the context of the Constitution and general laws. And the key cases of recently the city of Tucson versus...
All right, so you get the idea. As you saw in the video, there were no witnesses, there was no new evidence introduced. It was just the guy making constitutional arguments based off of prior cases. He was citing the results in the ruling in other cases. So I think we're going to finish here. We'll kind of end at this point. In our next discussion, we'll talk about the Supreme Court justices, how they came to be, and specifically how a Supreme Court case works, how the appeals process works within the Supreme Court. Until next time, have a great day.